heartbeat of Mother Earth. Good evening, everyone. Thank you for joining us tonight. Hi, Marcia. How are you doing? And I've got so many people, Veronica Martises, Lynn Gill. I want to welcome you all to a really awesome night with Russ Diabo, and I just got a message from Judy. I will be doing this one once Russell starts to speak. Russell Diabo, for those of you who have not met him before, was born December 25th, 1955, is the son of a Ganawagi Mohawk iron worker. I just love that. And is a member of the Mohawk Nation of the Ganawagi, married for 30 years to Joanna Anaquad, Mother Cree, Saulteaux, Father Delaware, Saulteaux, Treaty Number 4, Saskatchewan. They have 5 children between them. His wife Joanna has 3 children from a previous marriage known widely as Podebsky Sisters of Film, Music, Television, Theater. Russell, you have a wide range of work with what you have done all across this land, with the special work that you have done. At the time I met you with the AFN, I'm so happy to have had that opportunity to meet you at that time, and I really appreciate you coming on and giving us a full evening of yourself and what you do the best. Welcome, Russ.
Thank you, Nyawa, Marlene. Thanks for having me and hosting this. So did you want me to start?
Yeah, you can start now, sure.
Oh, okay. So good evening, everybody. I'm covering the issue of these 4 policies that are federal policies that are set out to replace or terminate the inherent or treaty rights of First Nations. And so I prepared a PowerPoint. I don't know if I can, if I'm hosting, to share the screen or not.
I just made you host, so yes, you should be able to.
Oh, okay. Can everybody see that?
Yeah.
Trying to figure this out. I'm not too good with this stuff. Okay. Okay, so everybody can see the screen okay?
Yes.
Okay. All right, so as I was saying, Marlene asked me to talk about the 4 policies, the federal policies that are in place to replace or terminate inherent treaty rights. So the first thing I want to say is that since 1995, the federal inherent right to self-government policy is the blanket policy for all discussions, negotiations, and legislation with First Nations, Métis, and Inuit regarding Section 35 Aboriginal and treaty rights, common law, as it's been laid out through court cases. These 4 policies form a negotiation framework and need to be read together, in my opinion, as a whole to understand the federal government's pan-Indigenous reconciliation approach. So the 4 policies are the inherent right to self-government policy, the modern treaty, or it's really the comprehensive land claims policy, the specific claims policy, and the additions to reserve policy. These are the 4 policies that are in use by the federal government. And so I just I'm going to do a bit of an introduction or background to this, and then I'm going to go through the 4 policies. And then I want to talk about the role of these BC-based national land and fiscal institutions. And just talk a bit about Bill C-15, the United Nations Declaration Act, which became law in 2021. And I just want to end off with talking about the need for community research plans by First Nations to counter what's going on. So the first thing you need to know is that Pierre Trudeau and Jean Chrétien have left us a legacy, which includes Pierre's son, Justin. What we're dealing with as First Nations across Canada is a direct result of the actions that these politicians have taken. Starting with the 1969 white paper, which was publicly withdrawn in 1971, but it's still been implemented, except they've extended the time frame and they're implementing it in components rather than as a whole. But in 1969, the main thing they wanted to do was to eliminate Indian status. And they wanted to do that by removing the legal distinctions between Indians and Canadians through a number of measures, like dissolving the Department of Indian Affairs within 5 years. Well, they only dissolved the Department of Indian Affairs in 2018, but they did do it. They wanted to abolish the Indian Act and remove Section 9124 from the Constitution Act 1867, which is the section that gives exclusive legislative authority over Indians and lands reserved for Indians to the federal parliament. They wanted to repeal that. They wanted to convert reserve land to private property so that it could be sold by the band or its members. That's already happening now. They wanted to transfer responsibility for Indian affairs from the federal government to the province and integrate these services into those provided to other Canadian citizens. The offloading that Canada is doing is heading in that direction now. They said they would provide transitional funding for economic development. The federal government does provide funding for economic development now. And they wanted to appoint a commissioner to address outstanding land claims and gradually terminate existing treaties. And I would argue that they've been doing that through their land claims policies and getting rid of treaties incrementally as well. And I'll get into that. But also in terms of abolishing the Indian Act, that's in the National Action Plan. They want to get rid of the Indian Act. They've said that openly now in June of this year, they said that. So in addition to the white paper on Indian policy, Pierre Trudeau and Jean Chrétien in 1973 issued a statement of native claims, and that's where these land claims policies came from. There's two land claims policies: comprehensive land claims, which were parts of Canada where there weren't land treaties, like in British Columbia. In 1971, at the time, the Northwest Territories and the Yukon were part of that. Quebec is part of that because there were no land treaties in Quebec, and in the Atlantic provinces, there were just peace and friendship treaties, not land treaties. And the specific claims policy has to do with the lawful obligations. I'm going to get into these policies in more detail, but I just wanted to point out that it was Pierre Trudeau and Jean Chrétien who issued a statement in 1973. So the land claims policies that Justin Trudeau's government's implementing now are his father's land claims policies from 1973. They've changed a little bit since then, but not that much. And also Pierre Trudeau and Jean Chrétien were responsible for the Constitution Act 1982, bringing that back from England. And there's Section 35 in that Constitution that says originally the wording was the Aboriginal treaty rights of Aboriginal peoples are hereby recognized and affirmed. Through the negotiations, they threw that clause out and then they put it back in, but they
Hi,
added.
Russell, we can't hear you.
Oh, I can hear him.
Sorry, can you hear me now? Marlene? Can everybody else hear me okay?
I can hear you fine.
Yes, I can hear you, Russell.
Yep.
I can hear you fine.
So Marlene must be having some technical issues.
Yeah. Winona, Judy is in the waiting room.
Russ, could you add her in since you're the host now?
How do I do that?
Just click on the participants on Zoom.
Okay,
Then you'll see somebody in the waiting room, and then you click the blue button.
I
to look.
wonder, Russell, if you can turn it off and then maybe turn it on again. I'm not sure.
I don't see any
Okay.
buddy in blue. Oh, yeah, I do see admit. Judy.
Yes.
Can you
was-
let me know if Judy got in?
Yeah, I just admitted her. I'll just admit everybody that's here, I guess.
Winona? Oh, okay.
Okay, I think I've admitted everybody now. Okay, I think Judy's on.
Hi, Judy, is that you on the phone?
Yeah, I'm just coming from the Union of BC Union Chiefs meeting, AGA in Williams Lake, so I'm on the road and I'm hoping the Wi-Fi works.
Oh, there
okay.
we are. Hi, Judy. How are you? Glad you got to join us.
Yeah, I'm on the road.
Russell,
so
we
it's
still
probably up
can't
and down.
seem to hear you.
Oh,
Everybody else can hear me. Can you hear me, Judy?
Your lips are
I can
moving.
hear you.
If I could get Judy to, if you want, Russell is just trying to work out some glitches. Judy, can you can talk for a
No,
minute?
no, it's you. Marlene,
Yeah,
everybody else can hear me. It's only you, Marlene.
I'm gonna call her right now.
Okay.
Hi there.
Sorry, Judy, I was just starting, actually. Shall I go ahead?
Yeah, go ahead and continue. Marlene's gonna figure it out.
Okay.
Sorry about that, everyone. Thank you.
So I was talking about Pierre Trudeau and Chrétien's legacy, and I referred to the 1973 Statement of Native Claims, which creates the comprehensive and specific claims policies that are in use today. They were involved in bringing the Constitution or patriating the Constitution from England, putting the Section 35 wording, and they added a word. They removed that section during the negotiations with the premiers. When they put it back in, they added the word existing. So that Section 35 says, we hereby recognize and affirm the existing Aboriginal and treaty rights of Aboriginal peoples. And the Supreme Court in 1990 in the Sparrow decision basically interpreted that word existing to mean that Section 30, that rights that have been extinguished prior to 1982 can't be revived. Because Canada, under their law, was of the view that rights could be extinguished by the Crown without consent prior to 1982. So that word existing in Section 35 was significant. And there was a Section 37 in the new Constitution that provided for, that required the First Ministers' Conference on Aboriginal matters to be held within a year of the Constitution becoming law. So in 1983, they had that First Ministers' Conference, and they amended it to add on for 3 more First Ministers' Conferences because it was only required to have 1. And they also made other amendments, including recognizing land claims agreements as treaties. I'll get into that later. My point is that Pierre Trudeau was the Prime Minister. Jean Chrétien was the Minister of Justice during those constitutional talks. And in 1980s, in those First Ministers' Conferences, the main issue that was discussed was self-government. Is it an inherent right or is it delegated right, depending upon reaching agreements with Crown governments? They couldn't reach agreement on that, and basically those First Ministers' Conferences ended in failure, and Section 37 became empty or spent. And before he left, as Prime Minister, Jean Chrétien basically left behind the objectives of the white paper in in the 1995 inherent right policy, which he imposed. It has preconditions to negotiating self-government that basically transition Indian Act bands into becoming a federal municipality. And also Jean Chrétien also got Parliament to pass the First Nations Land Management Act in 1999, which creates land codes and land registries and this land advisory board, this national land institution. And also he tried to get the First Nations Fiscal and Statistics Management Act passed when he was still Prime Minister, but he left. It was part of his legacy legislation, but he handed it over to Paul Martin, who finally got it passed in 2006. And that created these national fiscal institutions. Now it's called the First Nations Fiscal Management Act. But this was all basically Pierre Trudeau and Jean Chrétien basically implementing the objectives of the 1969 White Paper through policy and legislation. So the Constitution Act 1982, with those constitutional talks ending in failure in the 1980s. Starting in 1990, that Sparrow case was the first court case defining Section 35. And we've had over 30 years of case law now from the Supreme Court of Canada, where they've laid out legal tests, basically to define rights and place the burden of proof on Indigenous peoples. And they recently, for the first time, appointed an Indigenous Supreme Court justice. And there's going to be a Supreme Court decision coming down on the Bill C-92, the Indigenous Child and Family Services Act. The Quebec government challenged that in court. It went to the Quebec Court of Appeal, and then it was appealed to the Supreme Court. So that decision is supposed to be handed down any time now, because they heard arguments about it in December. Usually it's about 6 months and they hand down a decision, but they haven't done it yet. It's been over 6 months. So it's expected that they'll hand down that decision soon about whether the Child and Family Services is an inherent right to self-government or if it's a delegated right based on Bill C-92. Quebec said Parliament went beyond its authority when it passed that law. So we'll see what the Supreme Court says, but the point is that the Supreme Court's defining Aboriginal and treaty rights in Section 35 through their case law. They've been doing it for over 30 years. So this nation-to-nation reconciliation approach that the Trudeau government's taking, Justin Trudeau's government, we need to make that clear, the current Trudeau, it's based on 2 tracks, 2 departments, 2 ministers. Indigenous Services Canada and Crown Indigenous Relations and Northern Affairs Canada. And there's 10 principles for Indigenous relationships, which were imposed in. Somebody needs to mute their mic. There's Zedar. Is it Zedar? You need to mute.
Oh, sorry. Sorry.
Zeder, can you put yourself on mute, please? Thank you. Okay, sorry, Russell.
Sorry, Molly.
Anyways, so in 2017, as the Justice Minister and Attorney General of Canada, Jody Wilson-Raybould imposed 10 principles for Indigenous relationships, which basically deal with the federal government's interpretation of the Constitution and also the UN Declaration. So there's 2 tracks, 10 principles, and 4 policies to negotiate Section 35 Aboriginal Treaty Rights. And in addition to that, there's these 4 BC-based national institutions to facilitate the transition of Indian Act bands and reserves into federal municipal self-government corporations. And all of that is now part of a national action plan to use the 4 policies to implement a federal interpretation of the UN Declaration objectives. That action plan was adopted by the federal government in June of 2023, June 20th, just before Indigenous Peoples Day. So this is the nation-to-nation reconciliation approach. It's based on these components. So in terms of the two-track approach to reconciliation, track one is based on, and this was announced in December of 2015 when the government had just been elected. Track one is closing the socioeconomic gap between Indigenous peoples and non-Indigenous Canadians. So that's the program areas, and really that's what Indigenous Services Canada is dealing with. And the second track is to make changes to laws, policies, and operational practices based on the federal recognition, I would say the definition of rights, to advance self-determination and self-government. And that's the mandate of the Crown Indigenous Relations Department. So those are the two tracks. One is really programs and one is rights. You know, closing the gap and changing law and policy. That's the two-track approach. And under the two-track approach, the role of Indigenous Services Canada is to prepare First Nations for devolution of programs and self-government through fiscal and administrative capacity building, including 10-year grants. It used to be bands, Indian Act bands would only get annual funding. Then they started going into like 5-year block funding. Now they're offering eligible bands 10-year grants. And the role of Crown Indigenous Relations is to implement existing self-government agreements. There's 22 self-government agreements affecting about 44 communities, including modern treaties and alternative to the Indian Act legislative arrangements through these national land and financial management agreement institutions. And they're using the existing modern treaties and self-government agreements and legislative arrangements to negotiate with the rest of the Indian Act bands or First Nations on this approach to negotiate inherent treaty rights through this inherent right to self-government policy. Plus, they've now adopted a self-government fiscal policy based on own source revenue. So there's two. There's a 10-year grant for the Indian Act bands, and then there's a self-government policy for those groups, Indigenous groups that go into self-government under Canada's policy. So that's the two-track approach and the role of the mandate of the two departments. So the 10 principles, I figured I'd list them, you know, because a lot of people just refer to them, but they don't really go into them. So I'm going to try and explain them a bit. So I've underlined some points here, which is why I've said emphasis added. So principle one, the government of Canada recognizes that all relations with Indigenous peoples need to be based on the recognition and implementation of their right to self-determination, including the inherent right to self-government. So I've underlined that because they have defined the inherent right to self-government in a policy since 1995. So that's the first principle, is they're using that policy. Principle two, the government of Canada recognizes that reconciliation is a fundamental purpose of Section 35 of the Constitution Act 1982. Well, the courts have said that already in Section 35 case law. But again, you know, they're using their policies to negotiate these rights. Principle three, the government of Canada recognizes that the honor of the Crown guides the conduct of the Crown and all of its dealings with Indigenous peoples. I think this is what my old professor, Vine Deloria Jr. used to call a legal fiction, because, you know, I don't really see the honor of the Crown existing outside of the courtroom. You know, when the lawyers call each other my friend. Outside, though, I see the relationship as being pretty adversarial. Principle four, the government of Canada recognizes that Indigenous self-government is part of Canada's evolving system of cooperative federalism and distinct orders of government. So again, Indigenous self-government is defined in a policy and through agreements that are reached under that policy. So they're just restating that because that's the basis of negotiations they're having with Indigenous peoples. Principle five, the government of Canada recognizes that treaties, agreements, and other constructive arrangements between Indigenous peoples and the Crown have been and are intended to be acts of reconciliation based on mutual recognition and respect. So let me decode this a bit. So when they're talking about treaties, they're talking about modern treaties. Agreements really mean self-government agreements. And other constructive arrangements really means land codes under the First Nations Land Management Act, or tax laws under the First Nations Fiscal Management Act. Those are the constructive arrangements. So it's really, because I'll get into it, but the historic treaties, they're using the self-government policy to negotiate implementation of historic treaties, because there's historic treaties and there's modern treaties. Anyways, that's how I read that principle. Principle 6, the Government of Canada recognizes that meaningful engagement with Indigenous peoples aims to secure their free, prior, informed consent when Canada proposes take actions which impact them and their rights, including their lands, territories, and resources. So I've underlined aims to secure because that's watering down the UN Declaration standards. I believe it's Article 32 that says states shall obtain the free, prior, and informed consent of Indigenous peoples, not aim to secure getting their free, prior, and informed consent. So that's given Canada's interpretation of the UN Declaration and that principle. Principle 7, the Government of Canada recognizes that existing and Aboriginal rights are essential and that any infringement of Section 35 rights must by law meet a high threshold of justification that includes Indigenous perspectives and satisfies the Crown's fiduciary obligations. Well, the infringement of Section 35 rights comes right out of the 1990 Sparrow decision. You can look this up because the Supreme Court laid out a test. They said in that Sparrow case that Section 35 rights are not absolute. They can be justifiably infringed for valid legislative reasons. So that's where they get in saying that consent, there's no veto. That's what they were going on about with the UN Declaration. And they're basing it on this Sparrow decision. So that's what's embedded in Principle 7 is really what the Supreme Court of Canada already said. Principle 8, the Government of Canada recognizes that reconciliation and self-government require a renewed fiscal relationship developed in collaboration with Indigenous nations that promotes a mutually supportive climate for economic partnership and resource development. Well, they have developed a new fiscal relationship. It's based on these 10-year grants for Indian Act bands to prepare them for self-government. Once you're in self-government, then there's a self-government fiscal policy. So that principle, that they've already done that. Principle 9, the Government of Canada recognizes that reconciliation is an ongoing process and that occurs in the context of evolving Indigenous Crown relationships. You know, that's really, you know, I guess kind of a rhetorical statement or principle, in my view. Principle 10, the Government of Canada recognizes that a distinctions-based approach is needed to ensure that the unique rights, interests, and circumstances of the First Nations, the Métis Nation, and the Inuit are acknowledged, affirmed, and implemented. I would argue that although they're referring to a distinctions-based approach, it's really a pan-Indigenous approach that this reconciliation process is, that's what they've been implementing. So getting into the 4 federal policies to replace or terminate inherent treaty rights. First of all, the federal inherent right to self-government policy is the basis for all negotiations, discussions with the First Nations, Métis, and Inuit, including at these processes, the recognition of rights and self-determination tables, which the current Trudeau government set up. Also the modern treaty or comprehensive land claims tables. There's about 50 of them, I understand, across the country. Self-government, sectoral or comprehensive tables. So self-government, they're saying it can be a sectoral self-government agreement or a comprehensive self-government agreement. A sectoral self-government agreement could be like for a program like education, taking over education, that would be considered a sectoral self-government agreement because it's not a full constitution setting out how you're going to govern your people and your land. That would be a comprehensive self-government agreement. Even the land codes under the First Nations Land Management Act are considered sectoral self-government. Because a band opts out of the Indian Act into the First Nations Land Management Act. It's still a federal law, but it's a different federal law than the Indian Act. And that's the alternative federal legislation to the Indian Act imposing national standards on inherent treaty rights. And so these laws, federal laws, have affected First Nations lands, taxation, resources, languages, child welfare, and governance regimes. So the federal government's been using the constitutional authority under Section 9124 for Indians and lands reserved for Indians to pass, the Indigenous Languages Act, the Indigenous Child and Family Services Act, the United Nations Declaration Act, all these self-government legislation that they passed. The Anishinaabeg Nation Governance Agreement Act, the Whitecap Dakota Self-Government Treaty Act. They've passed a whole bunch of legislation regarding self-government agreements. So that's the inherent right policy. It's the umbrella policy. So the 1995 federal government inherent right policy was referred to in the Red Book. Promise in the Red Book was that the Liberal government would act on the premise that the inherent right to self-government is an existing Aboriginal treaty right within the meaning of Section 35 of the Constitution Act 1982. And in 1995, they issued this Government of Canada's approach to implementation of the inherent right and the negotiation of Aboriginal self-government policy. And that's the treaty policy is the inherent right policy for the historic treaties, not just the modern treaties. And the policy says the Government of Canada is prepared where the other parties agree to constitutionally protect rights set out in negotiated self-government agreements as treaty rights within the meaning of Section 35 of the Constitution Act 1982. I've underlined this point. Implementation of the inherent right in this fashion would be a continuation of the historic relationship between Aboriginal peoples and the Crown. Self-government rights could be protected under Section 35. Either in new treaties as part of comprehensive land claims agreements or as additions to existing treaties. It follows from this approach that matters in agreements of a technical or temporary nature would not be appropriate matters for constitutional protection as treaty rights. Arrangements that must be adaptable to changing circumstances such as program and service delivery arrangements, funding arrangements would therefore not be appropriate subjects for constitutional protection as treaty rights. So right away, if you go into a self-government agreement, programs and funding are not included in the agreement. Those are still controlled by the central agencies. It's not considered a treaty right or part of self-government. Treasury Board rules and all of that will still apply to the funding arrangements. So the inherent right to self-government policy rejects First Nation sovereignty. It subordinates the collective inherent rights to the Charter, meaning individual rights over collective rights. It denies the inherent jurisdiction of First Nations, even though they say they recognize that there are some rights that are inherent. And even though they recognize inherent rights, they still require individual negotiations band by band. And the federal negotiators' mandate is to use the national self-government policy, which has preconditions to transition Indian Act bands into municipalities. And this inherent right to self-government policy is mirrored in 2018. The current Trudeau government proposed a rights recognition framework. They wanted to pass a law. And in that law in 2018, they were again requiring negotiation of inherent rights, even though there's actually been case law that recognizes there's existing rights that exist already. The proposed bill wanted to require negotiations of even those rights, which have been recognized. In the policy, there's three lists or tiers of subject matters. Like I said, what they recognize inherent rights are still subject to negotiation. And then there's a list showing delegated rights, things like divorce, marriage, those kind of things. They were prepared to negotiate a self-government, but they don't consider them inherent rights. They're rights that are delegated, and they're prepared to include those. And then there's a list of non-negotiable matters dealing with trade and commerce and national matters that they consider they won't share jurisdiction with First Nations in those items. The policy was rejected right away by chiefs in assembly, but even though AFN has rejected it, individual groups have went ahead and negotiated self-government agreements. There's 22 of them, and hundreds of band councils are at various discussion and negotiation tables, recognition tables, modern treaty tables. Since it's their blanket policy, basically all discussions with the government are tied under the self-government policy, because that's their objective, is basically to, get rid of the Indian Act and have everybody move into self-government. And the federal inherent right policy states the inherent right to self-government does not include a right of sovereignty in the international law sense. And implementation of self-government should enhance the participation of Aboriginal peoples in the Canadian Federation. So it's basically finishing the colonial project of, the Indian Act was designed to assimilate Indians or First Nations, and at some point it's going to end. So the federal bureaucracy has been after national legislation to convert Indian Act bands into municipal corporate entities that have the rights, powers, and privileges of a natural person at law for decades now. I was the Indian Act Amendments coordinator for AFN when Ovid McCready was national chief back in 1976-77. Bill C-79, the Indian Act Optional Modification Act, was proposed. And it said that the legal capacity of bands would be having the rights, powers, and privileges of a natural person. That was rejected. It died on the order paper when an election was called in 1997. It says 1979. It should say 1997. But it was repackaged under a new minister, Bob Nolt, as the First Nations Governance Act by the bureaucracy. And again, it was that a band has the legal capacity, rights, powers, and privileges of a natural person. So the First Nations Governance Act was also rejected. So twice trying to impose on national legislation to turn bands into having the rights of a natural person powers was rejected. And then again in 2018, this proposed recognition and implementation of rights framework legislation. It's the bureaucracy that keeps recycling these ideas to politicians of the day. So in 2018, that's what was proposed, was that there would be a bill introduced into Parliament, and that legislation would enable the government of Canada to recognize Indigenous nations and collectives as legal entities with the status and capacities of a natural person, and enable self-determined exercise of governance by federally recognized nations and collectives. So again, it was the federal government choosing, defining who they would recognize and how. That was included in the proposed bill, but it's all based on the self-government policy. And it affirmed Canada's intent to enter into government fiscal relationships with recognized nations and collectives, and require Canada to co-develop further measures to support these elements. Well, this was also opposed by First Nations across Canada. So this was the third attempt to try and get a national law to turn band councils into, having natural person powers. And what are natural person powers in the context of self-government? Well, Alberta was the first province in Canada to provide municipalities with natural person power. With natural person powers, municipalities have the capacity, rights, powers, and privileges of a natural person, subject to the limits set out in the Municipal Governance Act, and can therefore exercise broad powers that are not explicitly set out in legislation. These powers address daily operational matters such as entering into contracts, acquiring property, and hiring staff. Basically the municipal charters that each province has, they set out the parameters of the lawmaking power of a municipality. So in terms of, in the context of self-government, according to the Government of Canada's website, self-government's negotiated within the Canadian constitutional framework, which means federal and provincial powers, orders of government. and federal legislation is passed before negotiated agreement takes effect. So Indian Act bans are considered non-self-governing because they're controlled by the legislation and by the department and the ministry. So they don't recognize any inherent authority or sovereignty. So that's why when you opt out of the Indian Act into a self-government agreement, you don't have any powers outside of the Indian Act until Parliament passes a self-government bill. And that's what that's saying, that first sentence. And under self-government, Indigenous laws operate in harmony with federal and provincial laws. Indigenous laws protecting culture and language generally take priority if there's a conflict among laws. However, the Canadian Charter of Rights and Freedoms, the Canadian Human Rights Act, and other general laws such as the Criminal Code continue to apply. So basically, when it's talking about harmonizing laws, it's harmonizing with federal and provincial laws to being basically local self-government or municipal self-government, except instead of the province creating a municipality, it's the federal government creating it under self-government. So the Comprehensive Land Claims Policy, what they now call modern treaties, following the Supreme Court of Canada's Calder decision in 1971, in 1973, the federal government announced a Native Claims Policy establishing two parts to the land claims policy. Comprehensive land claims were to obtain extinguishment of unceded Aboriginal title across Canada, and specific claims were to settle outstanding lawful obligations regarding the legal disposition of Indian lands or trust funds. And government defines, what the lawful obligations are. I'll get into that in the policy. And in 1975, the first Comprehensive Land Claims Settlement Agreement was signed in Canada, James Bay Agreement in Quebec. The Crees of Quebec agreed to extinguish their Aboriginal title in exchange for benefits under the agreement. And in 1983, following the adoption of the Constitution Act 1982, an amendment to Section 35 was made to add Section 35.3 for greater certainty in subsection 1, which is a section that says we recognize and affirm the existing Aboriginal treaty rights. Treaty rights includes rights that now exist by way of land claims agreements or may be so acquired. So what that did was that that amendment to the Constitution protected the 1975 James Bay Agreement, because the wording of that clause was rights that now exist by way of land claims agreements. So it retroactively gave constitutional protection to the James Bay Agreement, but also any other land claims agreements or modern treaties that happened after 1975 would have constitutional protection. So this 1983 constitutional amendment was added through the lobbying efforts of the Grand Council of the Crees of Quebec, who were signatories to the James Bay Agreement. And there were 6 actively negotiating comprehensive claims groups: the Nisga'a in BC, the Council for Yukon Indians, the Dene Métis in the Northwest Territories, the Tungavik Federation of Nunavut in the Northwest Territories, as it was then, the Council of Atikamekw-Montagnais, and the Labrador Inuit Association. So those were the 6 groups negotiating across Canada when that policy was announced in 1973. But they wanted to all get constitutional protection, so they all lobbied to get that Section 35.3 added in. So the 1983 amendment to Section 35 constitutionalized the legal distinction between the historic pre-1975 treaties with Great Britain, because those treaties are signed with Great Britain, not Canada, and the post-1975 land claims treaties, which placed the burden of proof on an Aboriginal group asserting Aboriginal title to prepare a statement of claim under the federal Comprehensive Land Claims Policy criteria. And the main purpose of the Comprehensive Claims Policy was to obtain extinguishment of Aboriginal title, which they did basically up until, recently. They've changed the wording a bit. So this is a map of Canada showing you the historic pre-1975 treaties. Also north of 60, those are basically the modern treaties that have been entered into. You can see in northern Quebec, the James Bay Agreement. The Council of Atikamekw-Montagnais came apart and became the Innu Nation and the Atikamekw Nation. Of those 6 groups that lobbied for the amendment to the Constitution, they're the only groups that didn't sign a modern treaty yet. The other 5, the Nisga'a, the Dene Métis, the Yukon, the Inuit, the Labrador Inuit Association, they all have entered into modern treaties, but the Innu and the Atikamekw have not. The Innu used to be referred to as the Montagnais, and now they're called the Innu Nation. So specific claims in 2017, specific claims justice at last policy was adopted. So it was a modification a bit of the specific claims policy that's been around since 1973. The term specific claims generally refers to claims made by a First Nation against the federal government, which relate to the administration of land or other First Nations assets and to the fulfillment of Indian treaties, although the treaties themselves are not open to renegotiation under the specific claims policy. Primary objective of the federal government with respect to the specific claims policy is to discharge its lawful obligation as determined by the courts if necessary. Negotiation, however, remains the preferred means of settlement by the federal government. The specific claims policy establishes the principles and process of resolving specific claims through negotiation. The Harper government did set up a specific claims tribunal to adjudicate, to be an independent body from the federal government to try and remove the conflict of interest in claims against itself. But they put a cap on specific claims that are valued at 150 million or less. So any specific claims valued at more than 150 million, there's still a conflict of interest with the federal cabinet deciding if they're going to resolve the claim or not, to negotiate it. So grounds for a claim: a First Nation might submit a claim seeking compensation for its losses based on any of the following grounds. A failure to fulfill a legal obligation of the Crown to provide lands or other assets under a treaty or another agreement between the First Nation and the Crown. B, a breach of a legal obligation of the Crown under the Indian Act or any other legislation pertaining to Indians or lands reserved for Indians of Canada or a colony of Great Britain, of which at least some portion now forms part of Canada. Now, B was added in because prior to 1990, the federal government refused to accept pre-Confederation claims, which was where most of the Haudenosaunee lands were taken, was before 1867. But it was only in 1990 with the what's called the Oka crisis that the Mulroney government agreed to accept responsibility for pre-Confederation claims, because Oka itself, the land dispute there went back to before Confederation. So that was added in as part of the specific claims policy, but it wasn't done until 1990. C, a breach of a legal obligation arising from the Crown's provision or non-provision of reserve lands, including unilateral undertakings that give rise to a fiduciary obligation at law, or its administration of reserve lands, Indian monies, or other assets of the First Nation. So treaties, reserves were promised at treaty. In quite a few cases, the reserves were not provided. And that's what this section is. It has to do with treaty land entitlement and also what's called cows and plows, promises of agricultural instruments. These are specific claims that are being addressed by the government now, but only through cash back, not land back. They're basically giving compensation in terms of money, not land. And I'll get into that. So D, another ground for a claim is an illegal lease or disposition by the Crown of reserve lands. E, a failure to provide adequate compensation for reserve lands taken or damaged by the Crown or any of its agencies under legal authority. Or F, fraud by employees or agents of the Crown in connection with acquisition, leasing, or disposition of reserve lands. And there was a lot of fraud by employees and agents of the Crown. That's why there's hundreds of specific claims across Canada. So the other thing is there's certainty and finality clauses in these self-government settlement agreements. The federal government requires certainty and finality when it settles a claim. Claim settlement must achieve complete and final redress of the claim. First Nations must therefore provide the federal government with a release and an indemnity with respect to the claim, and may be required to provide a surrender, end litigation, or take other steps so that the claim cannot be reopened at some time in the future. In any settlement of specific claims, the federal government will take third-party interests into account. The federal government will not accept any settlement which will lead to third parties being dispossessed. You know, they didn't mind doing it to Indians, but not to third parties. A claimant may use settlement money to purchase land, and any land purchased by a claimant would be on a willing seller, willing buyer basis. So basically, it's cash back, not land back. You have to buy your land back using the specific claim settlement dollars. So the policy also says First Nations achieving a settlement of their claims are expected to manage the proceeds of the settlement themselves. In the case of substantial settlements, the final agreement may specify the structure of mechanisms established by First Nations to administer settlement benefits. So these are slides on the addition of reserve policy to redesign it. These are from the government, from the Crown Indigenous Relations and Northern Affairs Canada Department, not from me, but I'm sharing them here with you to show you what they're saying. This is a map showing additions to reserves that are active and completed. So there are 432 approved additions to reserves since November of 2015, and approximately 692 active additions to reserve. That means they're in process, they haven't been settled. The land hasn't been transferred yet. These addition to reserve requests take 7 years or more. There's a backlog of hundreds of them. Well, as it says here, 692 active ATRs. So those are requests that are being processed. And you can see quite a few of these are in the prairies, you know, where they've been doing treaty land entitlement settlements. So when you get the money from a specific claim, you can then take that money, part of it, and buy land back, and then get it added to the reserve through this policy. But like it takes 7 years or more. There have been cases of expediting it or speeding it up. But, you know, I'm sure that's political intervention that does that. So additions of reserve is the process. This is the government's position. Additions of reserve is a process by which land is added to an existing reserve land base of a First Nation, or new reserves are created for First Nations without an existing reserve, because there are what they call landless bands. They're recognized as bands under the Indian Act, but they don't have reserves. I've worked for one of them anyway. The process can be triggered following a legal obligation, you know, which is basically settling a specific claim, a request for a community addition, or through a tribunal decision, which is that specific claims tribunal. The tribunal can award money, but not land. So the federal responsibility for additions of reserve is shared between the Minister of Crown Indigenous Relations and the Minister of Indigenous Services Canada. The Minister of Crown Indigenous Relations is responsible for the additions to lands on reserve and a Reserve Creation Act. Because in 2018 there was a law that passed, you know, basically putting this addition to reserve policy into law, and the First Nations Land Management Act, including the authority of the to issue ministerial orders pursuant to these acts to set land apart as reserve. So that's under the mandate of Crown Indigenous Relations. The Minister of Indigenous Services Canada is responsible for the administration of the addition of reserve process and ensures that all requirements of the addition to reserve policy have been addressed. By adding lands to reserve, the Government of Canada helps advance, in their view, reconciliation, fulfilling legal obligations, improving the treaty relationships, and fostering economic opportunities. So the phases of the addition of reserve process are: phase one is the First Nation submits a proposal to the Indigenous Services Canada Regional Office. Phase 2 is an assessment and review where Indigenous Services Canada reviews the proposal, advises the First Nation in writing of the results, issuing a letter of support to the First Nation with successful proposals. Phase 3 is proposal completion. Indigenous Services Canada and the First Nation work together to create and execute a work plan to complete the proposal. This is a very bureaucratic process. 4 is approval. Indigenous Services Canada prepares the ministerial order submission, and the Crown Indigenous Relation and Northern Affairs Canada obtains ministerial approval. So the two departments are working together. Remember, the objective is essentially to dissolve Indigenous Services Canada. It's considered a temporary ministry until everybody's moved into self-government under the Crown, and a new intergovernmental relationship under self-government. So the background to the addition of reserve policy in 1972, the policy guidelines were formalized in 1982. Policy focused on the land base serving social purposes for First Nations communities rather than economic development. In 1991, the policy was amended to include environmental assessment criteria and a procedural framework to allow for more uniform consideration of additions to reserves. In 2001, the policy was amended to facilitate urban reserves and reserve creation for economic development purposes. In 2018, which would be under the current Trudeau government, the first addition of reserve provisions were added to legislation, the Framework Agreement on First Nations Land Management Act. In 2019, additions of lands to reserves and Reserve Creation Act came into effect. 2021, Crown Indigenous Relations and Northern Affairs Canada mandate is to accelerate ongoing work with First Nations to redesign the federal policies on addition to reserve and the specific claims process, because the two are kind of related, because like I said, specific claim settlements, you get land back, cash back, and then you have to go through this policy to get the land you purchased added onto the reserve land base. So under the addition of reserve redesign, according to the federal government, the First Nations-led engagement strategies and policy design are underway. Transformative change. Addition of reserve policy and process are due for a comprehensive redesign led by First Nations. Discussions at all levels, broadening the reach of engagement by including Indigenous organizations like the Assembly First Nations and other government organizations. Advancing the implementation of the UN Declaration on the Rights of Indigenous Peoples Act, Bill C-15. So that's the addition of reserve process. I want to talk about the role of, I say they're BC based because these national land and fiscal institutions have their main offices in British Columbia for the First Nations Land Management Act and the First Nations Fiscal Management Act. And Manny Jules, who heads up the First Nations Tax Commission, has been working with Tom Flanagan, who some of you may know. When the Harper government was in power, they were working on privatizing reserve lands into fee simple under the First Nations Property Ownership Initiative. But that process of developing draft legislation to create the private property system is still going on under the current Trudeau government, except they renamed it to be the Indigenous Land Title Initiative to make it sound better. But it's still about privatizing reserve lands into fee simple residential lands. So Canada has a land registration process. It registers individual interests in lands. It actually has 3 land registries. The Indian Land Registry System is for the existing reserves under the Indian Act. Monique, can you put mute on? Can you mute yourself, Monique?
I did, my apologies.
And then the second land registry system is under the First Nations Land Management Act for the land codes. So that's a separate land registry system from the Indian Act registry system. And then there's a third land registry system for those who have gone into self-government who have accepted private property or fee simple. Because the modern treaties, that's basically how the lands are accepted. The reserves are converted into private property. So this is a chart showing you, this is from the federal government. So at the bottom is the Indian Act land management regime. This shows you that ultimately the goal is to get the bands into self-government, the land registry under self-government. The alternate land tenure, that's the one I was referring to. That's in between the First Nations Land Management Act or the land codes and the self-government registry system. The alternate land tenure is that First Nations Property Ownership Initiative, which is now called the Indigenous Land Title Initiative. So it's another interim step before you move into self-government. It's basically preparing you for a private property system and getting out of the Indian Act system, the reserve system. And these are the national land and fiscal institutions to facilitate moving into self-government. There's a Lands Advisory Board and First Nations Land Management Resource Center that helps develop the land codes and the land registry systems. That's under the First Nations Land Management Act. And then these three fiscal institutions are under the First Nations Fiscal Management Act. There's the First Nations Tax Commission, the First Nations Financial Management Board, and the First Nations Finance Authority. And what those fiscal institutions are is the First Nations Financial Management Board advises on First Nations, well, they certify if a band has a good fiscal management system, and they give a certification for that. And also in developing a financial administration law and financial performance certification. They're in charge of giving eligibility for bands that want to go into the 10-year grants. They have to be certified by the First Nations Financial Management Board before they could be eligible. And part of that is they have to develop a financial administration law. And so the Financial Management Board oversees all of that. First Nations Finance Authority, they provide financing services. There's a revolving loan fund, if you're a member of that authority. They provide advice and investment services. The First Nations Tax Commission advises on.
You guys want to come?
Somebody's not muted. Jose Van Amero. So the First Nations Tax Commission advises on real property tax on reserve. Indian Act bands under Section 83 can do bylaws, but if you go into the financial management agreement, you can do tax laws and get delegated authority, to collect taxes in an arrangement set up under Finance Canada, but through the First Nations Tax Commission. So in 2016, AFN signed a MOU, a Memorandum of Understanding, to create a new fiscal relationship. That's led to a 10-year grant, which they call mutual accountability. The Financial Management Board, you can see, is listed in there. They have to certify before a band can be eligible to enter into the 10-year grant. Otherwise, they get annual funding. This is a chart I created, a graph I created just to show that the Indian Act band can go through different processes, but they all lead to full self-government status as a municipal corporation, having natural person powers. Whether you go in the recognition table discussions, modern treaty tables, self-government tables, or these alternative federal laws, even land codes and tax systems are just to help transition into self-government. There's steps along the way. And Crown Indigenous Relations is annually managing the transition of First Nations into self-government so that they'll know when that they can repeal the Indian Act and dissolve the Indigenous Services Canada. So annually, Crown Indigenous Relations is measuring the annual number of priorities identified through the permanent bilateral agreements with the Assembly of First Nations, the Métis Nation of Canada, the Inuit, Tapers Kanatami, the three national Indigenous organizations that result in policies, funding, or legislation. They're monitoring the number of communities where modern treaties or self-government agreements or other constructive arrangements have been concluded, which is the land codes and tax laws. They're monitoring the number of modern treaties, self-government agreements, and other arrangements that have been concluded. And the average community well-being index score for modern treaty and self-government agreement holders. They don't keep an average well-being index score for Indian Act bands, only if you enter into these modern agreements. And they're also annually monitoring the percentage of First Nations that have opted into an Indian Act alternative, which is the Land Management Act or Fiscal Management Act. Percentage of First Nations with fiscal bylaws or laws. Percentage of First Nations with established land codes, getting out of the Indian Act into the First Nations Land Management Act. The number of specific claims settled by the department. The percentage of active addition of reserves that have been in the inventory for more than 5 years, which are in the hundreds. So this is from the 2022-2023 plan, but it seems to be in every plan that the department puts out every year. So Bill C-15, the UN Declaration Act on the Rights of Indigenous Peoples, is based on Section 35 common law. And over the last 30 years, that common law has led to the imposition of Crown sovereignty over Indigenous peoples, including self-government rights. Cases have disregarded Indigenous laws and legal traditions. Supreme Court's established the Crown has ultimate title to the land. They said that in the Chilcotin case in 2014, that the radical underlying title belongs to the Crown. There's a burden of proof imposed on Indigenous peoples and nations to establish their rights in the courts. The legal tests, which cost millions of dollars to meet. The racist and frozen in time Vanderpeet legal test for establishing Aboriginal rights. The Vanderpeet test, which came down, I think, in 1996, said if you're going to assert you have an Aboriginal right under Section 35, it has to be a custom, practice, or tradition you did prior to contact, and it has to have survived contact. So that's a pretty high, burden of proof to meet. But that's, part of Section 35 interpretation. And they've replaced free, prior, informed consent in the UN declaration with the government's lower domestic standard of the duty to consult and accommodate, which is nothing more than a procedural right based on administrative law principles. Basically, they do a strength of claim assessment and they do a depth of consultation assessment. All the provinces have consultation policies doing that. And the federal government does that as well with all projects or activities. So they determine, the depth. Is it just a notice, or do they have to actually do accommodation measures, change, and stop a project? So anyway, sorry, I'm just letting some people in. So really the interpretation of the UN declaration through Bill C-15 is basically using domestic case law. And the problem with the UN declaration, this 2007 version that was adopted, because that's the third version that went through the UN, is Article 46.1. Article 46.1 says nothing in this declaration may be interpreted as implying for any state, people, group, person, any right to engage in any activity or to perform any act contrary to the Charter of the United Nations or construed as authorizing or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states. Now, the counterpoint to that, in my view, the most important article in the 46 articles of the UN Declaration is Article 3, which confirms that Indigenous peoples have the right to self-determination. And by virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So that seems to confirm that the UN Covenant on Civil and Political Rights and the UN Covenant on Economic, Social, and Cultural Rights applies to Indigenous peoples, because it's referred to here in Article 3 in the UN Declaration, which is legally non-binding, but the UN covenants are. So Indigenous peoples do have a right to self-determination. So in order to counter this national reconciliation plan to terminate collective rights, I'm saying that each community needs to do their own research plan. And in order to, the research has to consider specific research projects like a land use and occupancy study, community mapping, a harvest study, everything that's coming in from the bush, all the wild meat, cordwood, all of that needs to be probably done over a year and get a good baseline for what the communities are bringing in off their traditional economies. Toponym or place name studies, that's important to show the long-term occupation. Indigenous knowledge or traditional ecological knowledge studies are very important for, resource use and management, maintaining a connection to the territory. Documentation of customary traditional laws and treaties. Archaeology, written history, and ethnography. That's because the courts have put the burden of proof on us. These are all important sources of evidence or information that we need to collect, including genealogy, to show that we're descended from peoples, have existed in these lands for thousands of years. And finally, an alienation study and state of the territory, because, for hundreds of years now, reserves have been created, and surrounding the reserves, the provinces have issued permits and licenses for occupation and mining and forestry and hydro and oil and gas and you name it. And so the land is being continually alienated. In fact, there's cumulative impacts that have occurred already. So the remaining lands and resources need to be identified for current and future use. Each community needs to do that report by doing these studies and doing a map showing what lands are overrun by third parties and which lands are left for them to use for the survival. I would call it a survival plan. So basically, that's what I'm saying is communities need to take action, exercise their right, get the people organized to exercise their rights, but you need that information or evidence. Otherwise, you wind up in court, injunctions to police. So the first step is to organize the people, and then the next step is to plan and prepare a self-determination plan to exercise it on the ground or implement it. And that's my presentation. Sorry I took so long, but I was covering a lot of ground here.
Hi, thank you so much, Russell. The 4 federal policies, it is a lot of to really understand, where you want to replace inheritance and our treaty rights. And it is a lot of information, but, this is being recorded so that therefore people can go back and see what your presentation is all about. And I think I've got Judy on. I was just asking her if she can talk now. She's still available. Hi, Judy. There
Sorry,
you are. Hi, Judy.
I'm just right in the middle of a parking lot in Cannon Lake, hoping that you can see me all right.
Yeah.
Yes, I can see you, Judy. I want to just introduce you to everyone. First, Judy, she is the chief of the Nisconnelis Indian Band. She's also the secretary treasurer for the Union of BC Indian Chiefs, and she is currently just traveling, I believe, from Williams Lake to Kamloops, and is able to find some Wi-Fi so she can join us also. Thank you so much, Judy, for coming on. And how are you doing? You can unmute yourself now.
Yeah, sorry about that. I'm not the chief anymore. I had elections in January, and I think
okay.
Votes. But my family's been involved in all of the political history. But Russ just outlined. It's kind of, my uncle, Grand Chief George Emanuel, my dad, Grand Chief Joe Emanuel, and Chief Arthur Emanuel and Chief Bob Emanuel. It goes a long way. And Russ actually worked for many of the chiefs, including myself, for many years. And his important expert advice on all these issues is always really important. And I'm no longer on the executive to the Union BC Indian Chiefs. So I was there as a proxy today. I still do a lot of the important work on the land rights and the rights for, our residential school survivors and our missing murdered women and, child and family. So I was there to take care of some of the resolutions and some of the issues today, but or last 3 days, or it was hosted by the Williams Lake Indian Band. But all of the things that Russ has talked about is so important to know. He does a lot of different presentations to each community. I can't say enough about the research because the burden of proof is still on us. Even though we've had the UN declaration in BC, the DRIPA Act, it's still not far enough in regards to the onus of proof is still on us. A lot of legislation is still there. The referral system is still the same out of Delgamuukw, low notification to our communities about, any of the land or resources. And also, the regime that the reconciliation framework that the government is doing is still, even though they're saying, we want your input, we want to co-develop it. You can talk to many of the chiefs. They would not say they felt a lot was co-developed, thought it was rushed. The federal legislation was rushed. We did intervene as much as we could at the AFN level, and on the grassroots community level are being left behind because they're not getting a lot of the information, and it's so much to go through, right? And it's all framed in, and they do every step along the way, and you have to be very careful on any agreements you sign. Our community hadn't signed a lot of those agreements, but things are changing now. A lot of the chiefs are changing now, and they don't have all of the background and information that Russ is saying. He did help us develop our land rights strategy for our community. It needs to be policy. It needs to be implemented in that way. Sorry, I hear somebody else on the line.
I think that's Edward Willie. If you could mute yourself, please. Thank you. Okay, sorry, Judy.
Yeah, and so that was all our lived experience and all of the things that we've come through since Doctrine of Discovery. Russ usually talks about that, and as you know, that's part of the, again, fictitious notions they came in with and annexed all of our land, and they continued to use it in the court systems. They continued to use it in even though the Pope revoked or rejected it, it didn't quite revoke it. So there's so much important work to go in to revoking the Doctrine of Discovery, because I don't know how another country can come in and just annex the land when our people were here, where we were the original inhabitants, and we were occupying the land, and we had our own governance systems. That's why they try to say we were savages, so we didn't have any of that. So basically that we didn't have any rights to the land, but we do. And our laws, I always say our laws and our jurisdiction legal orders, like our own knowledge and our own ways, like our place names, our ceremonies, our ways of knowing, all of those things are first and foremost, because that's what makes us distinct nations, peoples. That's first and foremost. The UN Declaration is just a minimum human rights framework. And so I'm reminding everybody that, no, we have our own laws, our inherent child rights or laws, or whatever you want to call them. In our language, we have them, which is actually stronger when you say it in your own language. The way we say land is Tamil. So we have our relation with Tamil. We have our caregiving, caretaking responsibilities to Tamil. The Creator already gave us our teachings and our laws to how to take care of the Tamil. So we're inherently related, and we have reciprocal relationship to the land, and that's why it can't be severed. And so all of those are different on the property law. Basically, the way the government is doing the legal framework, reconciliation framework, the legislation and policies is actually to do away with our collective rights, our communal rights to the land and our teachings and stuff. So they're trying to make us individuals so they can make it property or municipal fee simple lands, or also that we don't have any collective rights anymore. And that's all of the assimilation and extinguishment work that's still happening. We call it this de facto extinguishment, which means it's still occurring to sever us from the land. So that's why all of this is important to know. And there is the the resistance that has happened over the years for many of our communities, and you hear it from time to time, but our Grand Chief says it's been too quiet, right? Like we have to continue the land resistance because it's really the continued encroachment in our territory. We have something called the Nisqually Douglas Reserve Claim, which is just our small community that our ancestral chief laid out. And it was like he called it like a big garden, a big ranch. And the year after he did the work to map it out and stake it out in 1862, Trutch came along a year later and posted preemption of the land. So basically, he posted in Kamloops the sale of our land, right? So he was already selling our land, and the process was still in process with the colonial government, and he was selling our land. So he was selling it to settlers, so people that would come in and in our territory without our permission. And so he was already doing that. So that's why, our lands were cut to a mere fraction of what we had. It's considered a mega claim. So again, there's just so much that the government has done and they're continuing to do through this inherent self-government policies, the policies that Russ talked about, the comprehensive policies. And they were all intentionally laid out that way. So you always have to be very, very careful on everything that you're signing on to, looking at, or discussing at these different tables, because they have their intent. But the biggest thing I'd like to say, if there's any takeaways from here, is that we have to be doing our own work. Yes, they're doing all that stuff, and they're going to continue to do that stuff. Because that's what our elders say. It's like distracting us, from the work that we need to do. They're going to continue to do that. We do need the watchful people like Russ, the experts, watching what's going on, so we know. But again, we have to, as Russ laid out, we have to have our own strategy, and we have to have our own work that we're doing. So the work is connecting to the land again, or building our relationship back with the land, the language, and the culture. And it's also about doing the research on the history of the land, and because the burden of proof is still on us, unfortunately. So we have to make sure that information is there, because a lot of our elders passed away, like us. A lot of our rights-based elders passed away from COVID. So that's like knowledge from hundreds of years, because they had collective knowledge, right? So that's really important to do that work. That you have to have that as your foundation, and continued keeping the language and culture alive in the ways of knowing and ceremonies. That's important. And also teaching this to the next generation. Today I saw a lot of younger chiefs today. So a lot of them, are they getting this information? Are they understanding it? So they're not feeding into the government program or the government agenda. So that, and keeping our people aware of this. My cousin Art used to come to our community all the time, from his travels around the world, or, all the work that he was doing. He would just sit there with a PowerPoint, and he would just sit there and he would explain what's going on. It didn't matter if one person or two people or a handful came out. I always made sure I went down there, because it was always so interesting to hear not only just the history, but, just getting it, understanding it. Because even with the PowerPoint today, with what Russ is showing, I've probably seen that a few times, but I'm always seeing something else through it, and getting ideas on how we can continue doing the work that we need to do in our communities to protect our own land and water, and our culture and our language and our ways. And that has to be a real foundation. Otherwise, we're just assimilating ourselves too. So we have just as much work to do, and we can't leave it in the hands of somebody else. It's our matriarchs, it's our grandmothers, grandfathers, our elders, our knowledge keepers. And I'd like to say, though, I'm involved in a lot of residential school work that's being done to help deal with not just the issues, but alignment and reset. Matriarchs, building those frameworks to support the work of the matriarchs, and missing murdered women, all of those things. But they're all designed to bring us back together, so that we're not divided the way the government did that to us through 60 scoop, putting us on reserves, the oppression, and residential school, et cetera. All of that was done with a design to do away with Indian people, kill the Indian in the child, and do away with as the Indian solution. they called it the policymakers. So we have our work cut out for us. And I see a lot of the amazing work the youth are doing, and the grandmothers, matriarchs, and the knowledge keepers, a lot of the men too. So I see it happening. It's just sharing that, and how are we doing that? So we're teaching our laws, we're teaching our way of knowing, we're teaching how we're connected to the land. So that's just sort of like a flip side, I guess, of what Russ is talking about with the legislation and policy and all the history that's happened to us. But we have some important work within our communities. We have some important work that we need to secure to do for our future generations. Otherwise, what are they going to have? And I'd like to say, even though maybe some of the leadership are signing those agreements, they didn't have free, prior, informed consent of the people, and a lot of the meetings I go to, sometimes the elders grab me and they say, you got to get up to the mic and you got to tell them they do not have our free, prior, informed consent on whatever the issue is. So usually that's what I do. At the beginning, I didn't understand it when I was a younger leader, why the elders were getting me to say that, but I understand it now, and it has to go on record that is not being consented to this or to that. So, and the elders, are very busy, and we have to be able to provide them with the resources necessary that the elders need. And elders also told me, they said, don't put us on pedestals, because we're still learning too, because the residential school took away a lot. So they're in that process, but when they're together, they have that collective memory, and the collective memory comes alive through them. And I've actually witnessed that myself. And it was a beautiful experience to see our elders come back with that collective memory. And some actually, their language was severed from them. And when the language, as latent speakers, when the language comes back, it's so powerful. And I've actually seen that in our communities with the language teachers, that they bring that back, and they go through. It's just powerful when the elders wake up and they got their language back. Or one elder told me he didn't have his language; it was beaten out of him, and he went to the sweat lodge. His elders told him, go to the sweat lodge and you pray for your language to come back. And he did that, and he's got his language today. So there's, again, our ways of knowing that are powerful and that can do that. So I'm happy, even though I'm not chief anymore. Under the Indian Act elected system, you got to remember that now I'm more freer to work with matriarchs, more freer to work with our knowledge keepers, and participate in all of the different ceremonies, and just support the work that a lot of our nations are doing, not just in our region, but throughout Canada, and actually even internationally. I've been invited to ceremonies too, so I see that resurgence, if you want to call it, or just that way. It's time to wake up. That's my mom always says, it's time to wake up now. We have a lot of work to do. So Marley, I didn't know if that was kind of the thing you wanted to. I actually
That is
could
awesome,
go into all
Judy.
that history that Russ put out there, but I don't want to repeat anything. I think he put a pretty good presentation together, and I know Russ can zoom into different communities and explain this stuff, and even if it's component by component, because sometimes all of it all at once is so much, but that's how Russ's mind works. And I think I hope Russ has his book going, and I hope Russ has a film coming out, because this needs to be talked about. Thank you.
Judy, thank you so much. It is a lot of words into what the four federal policies to replace, terminate, inherit, and treaty rights, but it's all very important work. And like we said, this is it is on Marlene's Solidarity webinar, so it is being recorded. So people really need to can go back to information that Russell has put through, and also what you have said. So it is 8:29, and so if we could just leave the last half hour to some questions that anyone has for you, Judy. For the fact that Judy is on the road, and if anyone has something they want to share with her before. And then Russell also, and he will be back on. And so I wanted to say thank you for everybody for being patient. And I've got one person, Joan Russell.
Yeah, if I could go first for any questions, because I think I just have to go now.
This is for Judy. Yeah.
Certainly. Okay, thank you.
Yeah, this is for Judy. Joan, if you could put yourself off of mute. You're muted, Joan.
Yeah, I'm muted.
Okay.
Well, actually, it's for both of them that I was wondering if NAFTA has anything to do with this. I can remember years ago, Canada and the U.S. were very concerned about the ejidos in Mexico because they were an example of collective ownership, and they wanted Mexico to get rid of them so that they could privatize more of the land, the indigenous land. So I was wondering about that, and I was also wondering about. He mentioned about the International Covenant of Economic, Social, and Cultural Rights is legal, and that's very important. But the other one, covenant is also important. The covenant the covenant of civil and political rights, and under Article 1, it said no people should be deprived of their subsistence. And I just wanted to make those points, and I'd like the commenters both of them.
I could just be really quick and maybe Russ could delve into it a little bit more. Basically, this has been a global intention from the Doctrine of Discovery to eradicate Indigenous peoples around the world. So you bet that any of their covenants and any of their work that they did under Doctrine of Discovery, etc., and is intended to continue that eradication. So that's why we always have to be mindful and watchful. And we've had delegations go to the United Nations. I am now, but my cousin Chief Art Manuel used to go all the time, and I had to pick up a lot of that work. But to go and do the submissions and presentations, and today I still do a lot of submissions to the various United Nations special rapporteurs. And actually, the Union BC and Chiefs, when I was on there, we actually had the Business Council come right to our office, and we made submissions to them. So on record, we've made submissions to many, many various special rapporteurs. I think the last one I made was, I think last month, was to the UN Special Rapporteur on modern slavery and consequences. And we were scheduled to do another one with the Special Rapporteur on water and sanitization, but that's rescheduled to 2024. So we have to continue that work as it's really important to get on record, the continued assimilation and genocide that they're doing to our people. And I think, it is as it is, like explaining, it sounds really good what the government is doing, but this is really what's happening, and this is how it's really impacting us. So a lot of interventions, as you will, here in Canada, a lot of interventions at the United Nations, and there's a lot of groups that do a lot of different submissions to all those different covenants that I put in the chat because we just have to be always making sure we're on record for all of those issues. But as I stated, most importantly, what are we doing, within our communities, within our families, and within our nations, on the ground to protect our rights and to protect, our land and our water and, our ways of knowing. All of those are under assault, unfortunately, every day. Any one of those, and so it's always been a very much of a initiative from any of the state governments because they want our land and they want our resources and they want continued control of it. So that's why we're always pushing back, on these jurisdiction issues and things like that. But now we have time to work with our rebuilding our governance systems, our nations, and our people. But it really, for our nation, for example, our title is held collectively with our people. But again, because we've been under Indian Act regimes, a lot of there's continued notions that we're Indian Act bans. No, who created Indian Act bans was the government. They created the tribal councils and the bans. That's not our traditional way. So it's getting back to all that education and understanding. And when we get to that true governance, then we're not following, again, like as I mentioned earlier, the government agenda. But I'm going to unfortunately have to go. I'm going to listen as long as I can because I'm still going to be driving. And I look forward, and I thank you for everyone for coming into the circle today. It's important we become awake And thank you, Marlene, for hosting us. And thank you, Russ, for inviting me and that I'm able to be part of this presentation, Cook's Jam. And I see Sydney there. Big shout out. Hi, Sydney. How you
Judy,
doing?
thank you so much, and have a good journey on your way home, and drive safe, be safe, and awesome to hear from you again. And I've got about 4 questions, so I'll just put them on to Russell, and take good care of yourself, Judy. Thank you so much.
Thanks, Judy. It was good seeing you. I don't see you much anymore.
We don't see you
Okay,
too.
see you soon. I'll see you soon, Russ, hopefully somewhere.
Okay.
Hi, Russell. So you're back. So I have a few people that had questions. The first one I'm going to go
Good.
to.
Marlene, just before you start, I just want to point out that I put my presentation in a PDF form to everybody on the chat.
Wonderful.
So I've shared it.
Okay. The first person that put a question out, and I don't see him anymore, but I'm going to go to Lucy Everett. You had something. Just share what you had put there. I want to hear from the young people before I put, that what your thoughts are. Hi, Lucy.
Hi. Oh, I didn't have a question. I didn't have a
No,
question,
you
but
didn't have a question. You had your Lucy wrote, plus when the UN bodies tell Canada to change stuff, Canada just ignores them even through their signatories like the UNCERT, telling Canada to stop the CGL and the TMX. And that was it, Lucy. Thank you. And then I'm going to go to Thalenthaner. If everybody could put themselves on mute, please. Hi, Thalenthaner Savazi, you're next. Hi. Sayazi.
Hi, I'm Thinauthor Sayazi, and my English name, my slave name, I guess, Mary Jane Sayazi, and I am the descendant of Camp 10, Churchill, Manitoba, and my grandmother escaped from that, and I'm just learning about all of this because my people, the Denisotine people, have just signed on to the moderate treaty, and they have no clue of what they have signed themselves into. And it's called Yatin Nene, North of 60 Final Agreement, all of those, and they turned them into nonprofit organizations, and the government made them do all of that. So I have collected a lot of information, and I don't have a degree or anything, but I just need help to how to put it together so I can explain this to my Denisotine people that we are going to be no longer Dene people, and we are all. I sit here and I did my research, my homework, and I didn't believe that we were on a concentration camp, all of this so-called Canada. Today, I realize I am sitting here in prison as Denisotine. And I am more imprisoned more because of these modern treaties and turning us into municipal people that we are not. And it's not even with our agreement. We have no consent to that. I say no consent because I did not agree with this. I find out I'm Chippewan, I'm Denisotine, and I'm Athabascan. And I find out that Athabascans means uranium, copper, all those minerals. So when people say, when we call ourselves Athabascans, I didn't know about that until just now. And now we've talked about all of that, but where is our land, resource, minerals rights? The Crown didn't give that to us. And the Crown keeps that right now. I've read all of that. And this moderate treaty, it's not in there at all. And one more thing I wanted to say. If that's my right self-determination, I want to have that. I want my my land rights, my resources, because they're taking all of that out. All the animals, caribou, all of us are all sick. And the Dene people, all the uranium is all coming out of our backyards. And they don't know, I didn't know nothing about it. I had to leave my reserve, the reservation concentration camp, in order for me to learn, because I was completely brainwashed by the Catholic Church. And it is called esprit de corps. All of my people right now are under esprit de corps. How can a government give them that? They're under duress, the Dene people. We have just been under criminal chemical warfare that was injected in us. And now all of my people are under depression because they lost so much. And now they put this modern treaty on us, under us being a duress. That's another abuse on us. And we wake up every day in jail, not knowing the whole Nazi runs this residential school, the schools, the universities, the government system. And we sit under there. And I don't know who to say what to say, because my people are all divided. And now when I say that, they don't believe me. So I'm throwing out, or whatever is happening to me right now. I feel like they're winning. So I just wanted to say that. Thank you for listening, and thank you for bringing all this. Russell, thank you. Saruna, that means live a long life. I don't use Mossy anymore because it's borrowed.
Okay, thank you so much for sharing that. I've got Kevin Gian next, and then Lorraine Reckman, and then Kevin Moran. Kevin Gian?
Hello. Thank you very much for putting on this event and for me being here. Thank you very much, Russ, as well. I have a question regarding council Indigenous bands that are within the Greenbelt development, that there are Indigenous nations that are pro development, and then Indigenous nations that are not. And how do you, it's so difficult to find a way to help and to be supportive when there's conflicts even within the nations themselves. And I wonder and I worry and how even I hear since WAB's election win in Manitoba, there's even already I've heard people saying in my area that, you know, there's no support for that man, even though he just got elected. There's already no support from within the Haudenosaunee people, that from what I understand. How can that be addressed, Russ? Is there anything that you can say, sir, to try and shine some light the frustration that people have because of the conflict even within the nations themselves, that there can be seen as a progressive step forward in one province, but yet a step back in others? It's so confusing. Thank you for listening.
Sorry. I'll try and give a response. You know, amongst the Haudenosaunee, we have divisions ourselves, right, between our traditional governments and our elective systems. And we've had those divisions for quite a while, like generations. It's not new. You know, what's going on with the Wet'suwet'en between the hereditary chiefs and the Indian Act chiefs, we have that over here in the East. I would say a lot of those divisions are caused from the outside by government because they don't want to recognize our traditional decision-making processes. You know, they use the Indian Act band councils and band council resolutions. And in fact, that's what Trudeau did when he first got in. He suspended the First Nations, Harper's First Nations Accountability Act, so that band councils didn't have to be as open about, you know, their spending. They still had to do annual audits and everything, but you know, the emphasis wasn't on like it was under the Harper government. Plus, he came up with $30 billion in new money, so he basically took over the band council system and got them, you know, working with his government through this reconciliation approach. So the Haudenosaunee people that you probably heard not being supportive of Wab Kinew it's because he's a premier of a provincial government, an NDP government, so he's under a party system. Personally, I think, you know, I wish Wab good luck in his government because they have a majority government. I think they can do some things. He has Section 92 powers. The Conservative opposition can't stop him because he's got a majority, so they can pass laws and he can try and do things, but I'm not sure what he's going to do in his relationship with the treaty nations because all of Manitoba is covered under treaty, right? From Treaty 1 at the bottom all the way up to Treaty 5 at the top. And so I don't know what he's going to do about land and resource issues. You know, there were conflicts with the previous government with First Nations and government of Manitoba over hydro, forestry, mining, you know, moose management, all of that stuff. So I don't know what Wab can do as a premier and as a provincial government if he seems to not to want to focus on First Nations issues, to say that he's not covering everybody, right? So I don't know how he's going to govern, but I think he's definitely going to be a different voice than the Conservatives that are in Ontario, you know, Doug Ford, and Saskatchewan, which I call Mississippi North, and Alberta, which I call Texas North, because, you know, those are pretty racist provinces. And of course, their premiers are very racist. So he's going to probably shake things up on the prairies, you know, with those other two provinces. So I think it's a good thing. We'll see what he can do. But, you know, the divisions that exist amongst First Nations, a lot of that has to do with money and the way the government manages money. And money changes values, you know. And I don't think it's pro and anti-development. I think what it is amongst our leaders and our people is we want sustainable development that's not going to harm our communities, that you know. And there's a debate about that because there are chiefs that want to buy the pipelines that go into oil and gas at the time we're in a climate emergency, right? It doesn't make sense to me, but I'm pretty sure they're not talking to a lot of their people when they're making these decisions. And that's what I've been advocating is we need to go to our protocols and our customs on decision-making processes that involve the people. That's what our traditional government system's how it operated. But the Indian Act system pushed the people out of that decision-making and just you elect a chief and council and they have meetings and they pass band council resolutions, and that's what the government uses. So
thank you, Russ. I'm gonna go. I've just got a few minutes left, so I've got two more people. Lorraine Recommend, you're next. If we can just keep it short, then I've got Kevin Moran. Hi, Lorraine.
Hey.
Hi, Lorraine.
Good to see you, Russ. Thanks for the presentation. I thought you said it was going to be high level, but you went way down there. But I've got a ton of questions. Like one, I think I put in the chat about challenging Canada's assertion of sovereignty. And that, really troubles me is that Canada created the Indian Act Band Council system, and then it negotiates with the same bodies that it created. So it looks like a conflict of interest to me that Canada is negotiating with itself. And that was why I asked the question about band councils. And and the whole issue of sovereignty. So I just want to say, we are working with the Indigenous Action Canada, which is a new group that we created, and we're writing a challenge to Canada's assertion of sovereignty based on the repudiation of the doctrine of discovery. And I know it sounds a little bit nuts because, yes, we're in a colonial system with colonial courts. But the truth is, Canada is in a conflict. It's created these band councils. And I had two questions for you. One is very specific. Is a band council able to make a sovereignty claim? And the second question is, do you know of any nations that are working on reorganizing their original governance structures that predate Confederation? I have to keep it short because Marlene.
What was that last question?
Okay, do you know of any nations that are working on restructuring their original governance systems based on nationhood?
I know some Anishinaabe that are trying to do that, communities and peoples. Even the UN declaration, the watered down 2007 version that we're dealing with, Article 18 says that Indigenous peoples have the right to choose their leaders through their own decision-making processes and institutions. Canada has ignored Article 18 of the UN Declaration, and they focused on Article 19, which says that they will work with Indigenous representatives for any changes to administrative or legislative changes. And so that's the band councils. So that's what they've been doing, is working with the band council, band office system, and the chiefs organizations like AFN. But it's been top down, right? As soon as Trudeau got in, he worked with the Assembly of First Nations, the Métis National Council, and the Inuit Tepers at Kanatami. And so all the changes that they made have been top down. And that's why a lot of community chiefs don't even know, let alone people. And let's not forget that Trudeau has done this during a global pandemic. So from 2020 to 2021, our people weren't even allowed to gather for public health reasons. And that's when they were doing Zoom calls and negotiating with chiefs and passing legislation and stuff that our people still don't even know what went on. They're still learning about this now. Like passing that UN Declaration Act, right? They did that all during the pandemic. And a lot of our people are saying, well, we don't even agree with the UN Declaration, let alone this UN Declaration Act. So now we have the UN Declaration to deal with, we got the UN Declaration Act to deal with, and then we got the National Action Plan. So there's three pieces to that we have to navigate. And it's complicated, especially because they're interpreting it through domestic law and policy, the 4 policies I laid out, plus the case law. So the Supreme Court is going to hand down this decision on the appeal for the Indigenous Child and Family Services Act, which Quebec challenged. That's going to have ramifications across the country, whatever they say, right? Because even though it's going to be narrow on child and family services, they're going to discuss the issue of self-government. The Supreme Court has not ruled on self-government, whether it's an Aboriginal right or not. So this case is going to be the first case that they're going to hit on self-government. And whatever they say in there, that's why they wanted that new Aboriginal or Indigenous justice sitting on there, is to hear that case. They appointed her last November, I think, and they heard that case in December. So that's the first case that she's going to be part of to make a decision on. And normally they give that out in 6 months, but they heard it in December. 6 months would have been what, June? And so here we are in October, and they still haven't handed it down yet. So they must be struggling with what to write and what to rule on, because it also has issues to do with Quebec, right? Because Quebec's the one challenging it. Anyways, that's going to, whatever you're working on, Lorraine, that case is going to impact it. I'm going to tell you right now.
Okay.
We're all
Well,
going to
Russ,
be reacting to that.
I think I mean, what I'm trying to get at is that, like, I see there's two worlds, right? One world is the colonial construct, which is the Indian Act Band Council system. And outside of that world are the people, like Tenalter, Sayazi, who said we were under duress. We were negotiating in a position of duress. Canada was in a conflict of interest. So,
But
you know, our
here's the-
rights were
here's the-
extinguished. But wait, I
here's
want to
the-
ask you this. Is there any hope, right, for Indigenous people as Indigenous citizens of nations to organize, to challenge every decision that the Indian Act Band Council system has rendered? Is there any hope for us to organize outside the Indian Act?
Yes, the short answer is yes, but it's up to the people. The people are the rights holders, not the band councils. People have the right to self-determination, not band councils. They're colonial bodies. But the problem is, you know, I was a special advisor to National Chief Archibald, and that's what she was trying to do. She was trying to get an audit going of AFN about what was going on during the Bellegarde years, because Perry Bellegarde went along with Trudeau for 6 of the last 8 years. He was national chief. So he went along with all the legislation, this whole top-down approach. And she was also trying to renegotiate the agreement he did with, the bilateral agreement he did with Canada on this this bilateral mechanism, they call it. And it's a joint implementation committee between the AFN Secretariat, the directors, and the Assistant Deputy Ministers and Director Generals of Indigenous Services Canada and Crown Indigenous Relations. So they have a co-implementation committee to implement this UN Declaration Action Plan. And our people don't even know about that. And that's this top-down approach on how they're going to repeal the Indian Act and how they're going to issue a statement on saying they're not going to rely on the inherent right or comprehensive claims policy. But they're going to do probably like they did in BC, a sleight of hand, you know. It's still the recognition technique they're using leads to de facto extinguishment of rights when you go into these agreements. So we're dealing with legal, constitutional issues and international law issues. And, you know, most of our leaders are having trouble figuring that out, let alone our people on the ground. So I hear that lady, the Dene lady, talking about what's going on. I'm aware of them imposing that modern treaty. My point is that the national chief was trying to get a national political strategy going to counter the federal political strategy they're implementing, because we don't have a national political strategy. We have regional strategies being implemented by band councils and chiefs organizations to go along with things, basically funded processes to reach final agreements under self-government, you know, our modern treaties. And unless our people get together and network and use Zoom technology like this to meet and coordinate, we're going to be picked off band by band. That's the way they're doing it. And because we don't have a national strategy, you know, you know, basically Trudeau co-opted our leadership. So it's really the only hope is left in the people. So we need to figure out how to, you know, we had I Don't Know More, we had the Defenders of the Land, we've had other networks, you know this, right? So we need to figure out how to reorganize ourselves into another network across the country to mobilize the people again. Because, you know, the pandemic kind of threw us off too. Like I said, 3 years of that, right? A lot of stuff happened our people don't even know yet. So I don't blame the people, because you can't blame the people when they don't know that the stuff I laid out tonight, you know, most of them don't know about that this is what reconciliation means, you know?
Yeah.
Well, I just want to say thank you,
Thank
Russ,
you,
and
guys.
thanks for
Thank
keeping
you.
at it. Thanks
Thank
for
you,
keeping at
Lorraine.
it.
I wanted to say, I'm sorry, I wanted to really keep this short because I had Kevin Moran, you've had your hand up for a while, and we're just about to wind up. And Russell, I just wanted to say that for everyone that you did show on the chat that where they can get your presentation, they can copy that down. And we'll go to, yes, Kevin Moran, thank you. Are you still here, Kevin?
Yes, I'm still here.
Okay, go ahead.
Thank you. Thank you for hosting the Zoom. Thank you for the speakers. Thank you guys for the questions, everybody. That's one thing that I have a big problem with is how one hand shakes the other. And by that, I mean how Indian Ag bans are controlled fiscally through the government, and in turn, they control, or they have authority. I wouldn't say control, but they have authority over the people. And from what I hear a lot of in the grassroots area is that there's a lot of financial transparency and accountability issues. And the information's out there. You know, that's one thing I'll say about governments is they love to keep records if you know where to look, and then you can, you know, put pressure on your band councils to do the right thing. But a lot of the times they're not even sharing information with us regarding this. My only regret is I found out in September 2021 about this whole plan, but I was researching a completely different topic and I ran into this self-government and all this other stuff. But you know, slowly they're dwindling away our rights, or they're trying to you know, kind of paint us into a corner where we don't have freedom, the freedoms we have, you know, as collective rights holders. But there is stuff that's going to be challenging Indian Ag bans. It's going to be coming out shortly, you know, through courts. I know it's just like we all, like Russ said, we all have to network and speak and see if it's going to be the right thing to do, because we don't want to paint ourselves into a corner, you know, thinking we're doing the right thing, right? So it's good that we got to get the information out there, because a lot of people still don't know about this, and it's like trying to convince, you know, everybody says it's the white man we got to fear, but it's our own kind doing everything to us here. And
That's true. That's true.
Right. So I don't have nothing against, you know, one lesson I'll share from my grandfather was that when all four people come together, we'll be able to solve a lot of the big issues facing us globally, you know, regionally, whatever. Like, you know, our Mother Earth is on fire, you know, like we're warming up, and there's so much water, you know, the water is being contaminated. There's all kinds of other issues, and you know, it all starts with the rights that we have. Money for our rights doesn't sit well with me. It's not.
It doesn't last, for one thing.
No, it doesn't. I mean, our rights are the sole reason that we're getting that money. So if they think of it like, okay, if we're getting rid of all our rights, because if you read the legislation, if you read the agreements, you know, they have kind of weaselly words in there, like non-assertion. Okay, that means that you're not going to stand up and say this is wrong, because you can't. You legally said that you wouldn't do that. So it's definitely an uphill battle, and I appreciate Zoom meetings and interactions from, you know, a lot of the speakers here I used to watch on YouTube, and now I'm sharing space with them, and I love that. And I just thank you everybody for listening, and thank you for the presentation.
Thank you so much, Kevin. I'm just going to go through. I'm going to go to the chat, because so many people don't get really want to say things, but they want to share some things. Before Judy left, she did say, when I think Lorraine was asking, is there a band? Judy responded to that. It's the Escad band, formerly the Alkali, that are working on it. It has structure to that question that you were asking earlier. Marcia McDonald, she just says in Sequoiam in her language, Cook West system, slept to everyone, Russell, to Winona, myself, and Judy for such a wonderful presentation. And also there's so many messages. I don't want to really miss out on anything that anybody wants. Kevin Guillen says, the dish with one spoon, it has relations to all nations. And I believe that my chat has just gotten way too big, but
I did mention in the
one
chat.
thing that
If I could cut in, Marlene, for 2 seconds. I mentioned in the chat that anybody could email me with their questions and I could forward it over to Russ or Judy if they'd like.
Yeah, that's great. Thanks, Winona. I'm just going to read off a few more, and these are not questions; they're just a thank you for the presentations to you, Russell. It was a lot of knowledge, but they know that they've got the presentation to go look backward for the work that they do, and to thank you very much for this. It is, and you know, the 4 policies is a lot of work. And Russell, you and I have a lot of conversations, and you send me so many things that I keep at you all the time, that you've got to come on and we need to educate the people of this land, because nobody is understanding so many things that are out there. And all what Kevin Guian and all of you are saying right now, how all your nations are so split. Yes, I of all people would know. I'm with Wet'suwet'en. And I call it Wet'suwet'en divided by 5. It's the 5 clans, and it's really the hardest thing in your life to try to understand your own people and where we're coming from. We are all trying to do the just work that we have to do to keep to keep our people, and it's really difficult when Russell, you said one word: money beats all. Money changes value, and sustainable development is always put on the back burner because of just the wrong thing, how some people starting with the chiefs right at the top. And I think that this conversation could actually go on a lot further. Go ahead, Russell.
But that's the thing. That's why I'm telling all the communities that I meet with, they have to do research, mapping, and planning.
Yes.
You need the information, which is evidence, but also knowledge, not just for land claims or court or negotiations. We need that historical and cultural evidence for our children, and to use it to make plans for the future, but also for curriculum development, for education and stuff, right? And map making is very powerful. When we interview our people and say, where are the places you go and hunt, fish, and trap, and where did you camp, where did you have cabins, what are the cultural sites, battle sites, spirit sites, all those things. Once you do those use and occupancy maps, those are very powerful things, because then you can figure out what areas you need to protect. When the province comes in and says, well, we want to do mineral exploration here, or we want to log here, or whatever. If our leaders and our people don't have a good handle, we need to be good at information management, just as good as government and industry. Because otherwise we're not going to survive as distinct organized societies, as nations. We'll fall into the trap, the plan that the federal government has to turn us into municipalities instead of nations. And we'll be cut off between the communities, right? Because the province is controlling the land in between communities. And they're making the land and resource decisions and excluding us. So we need that information, that evidence, to figure out what are our priorities for the future, especially with food security and climate change. We're in a climate emergency, and we really need to do those plans. That's why I call them survival plans, because for many of our communities, it's with the government cutting us loose, because that's what it is. It's offloading their ongoing treaty and fiduciary obligations by forcing us into, own source revenue and all of that. We need to look after our futures. So I just want to say that research, mapping, and planning, those are the 3 things I've been telling communities they got to do. We haven't been good at that. We aren't good at databases, and we're not good at archives. But we need to get good at that.
That's why we had this whole evening with you, Russell. You've given us, the go-ahead of the information. I really appreciate that very much. Information management is it starts within ourselves. We got to manage ourselves and manage our people. If we're not managed ourselves, we have a hard time to deal with others, and that's a really good teaching. And like so many other things that you have, you and Judy have shared with us tonight, I thank you wholeheartedly. We've gone way over, and if there is not anything else, I want to applaud you, Russ. Diabo. You've just come out on top. Let's give him a big round of applause. Thank you ever so much for that. And also a big hand to Judy, and I hope that she gets home safely. And I want to thank each and every one of you from all across the land. I'm not sure where everybody is from, but I know Regina, you're from Victoria. Sherry, Lucy, you're from Vancouver. Sean, you're in Montreal. Here, Lorraine Reckman, she's in Ottawa. And I've got Kathy Coates, she's in Victoria. Chris Ford, I believe, is on the island as well. Kat, Montreal, and Jose, Montreal. And also I love the Dennis and I'm not sure where you're from, but I see that Marcia, she has been in Montreal here. Sherry, I remember I spoke to you earlier. I believe you're, well, the one of us the furthest away was Nova Scotia.
Well, Edward Willie's from California. I happen to know that.
Oh, wow, wonderful. That's awesome.
And I thought he had his hand up, but it looked like it went down.
Yeah, okay. And then Joan Russell, she's in Victoria. And so California, that's good. So I went all the way from California to all the way to Nova Scotia. She was on a half an hour early to make sure she was going to get on. I applaud her for that. And everyone else.
Edward Willie and I went to Berkeley together in the 70s.
Okay, that's where he's on there. That's wonderful. And Gary Spiller, thank you as usual for coming on. And I'm sorry I didn't get to everybody's. There's so much in the chat line, but Winona had mentioned you can get a hold of her by her email. And she's also put the information that will go up, and then also this is recorded and will be on Marlene's Solidarity webinar. Hey, and Lucy, that was developed by you so long ago, and thank you all for that. Brittany Hollingsworth, and again, you all have a good Thanksgiving weekend, and in Montreal, we have to stay dry. The rains have returned to us. And all of you have a good rest of the evening. Russell, thank you again ever so much. We have to have another big presentation by you again. And all of you, a good night. Good night, Lorraine, everyone else. And take good care.